Okay, folks, hello again. My name is Doug Pinkham with Pinkham & Associates. We are a dedicated family law firm in Orange County, California. But I am here to help you try to fill out the FL 341D. This is the additional provisions for physical custody. So this form is usually used when you're going to attach this form to other custody orders. So as part of a judgment, it could be part of a request for order. It could be part of a stipulation for visitation order, but it's attachment that gives further orders with regard to physical custody. All right, so like I said, you might be using this form to attach to your judgment, or you might be using this form to attach to a request for orders for physical custody, for custody orders. All right, folks, so I'm going to get into the form. I'm going to get right into it. Also, I know that some of you have the form up and can see it at the same time that you're seeing me, and others of you cannot. But if you cannot see the form, if it's not next to the video, then there's a link down below. Click on the link, print out this form, and have it with you, because I'm going to go line by line through this form. All right. Okay, so let's pull open the form, and let's start at the top. Just like every form, you're going to put the petitioner's name and the respondent's name and the case number. Again, as you know, I'm sure by now that the petitioner's name and the respondent's name never change. It's the same as the petitioner and the respondent from the original petition. All right. Then you're going to mark in the next box whether you're attaching this to a petition, whether you're attaching it to a response. More likely, you're attaching it to a request for order or a responsive declaration to a request for order, stipulation for order, or a findings in order after hearing, or a judgment. Okay, so mark the appropriate box, and then we're going to move on. Okay, so the next section says the additional provisions of physical custody apply to the petitioner or to the respondent. So these provisions that we're going to specify on this form, we're going to mark a bunch of boxes, and we're going to give some instructions or orders for notification, if you're going to cancel a visit, if you're going to maybe move. These are orders that go along with. So here's the point. So this provision might apply to both of you or only one of you. So you may need to fill out the form and then come back to this top part to see if it's just going to apply to the petitioner, if it's only going to apply to the respondent, or it's going to apply to both of you. So likely it's going to apply to both of you. So I would presume that you're going to mark both the petitioner and the respondent and then move on to fill out the rest of the form. So let's move on to number one. Section number one is notification of parties' current address. Obviously, you want both parties to provide a current address of where they live to the other party. So mark number one, and then again, both of you should be giving notice if you move or if anything changes with regard to your address. I would say within 3, 4, or 5 days of changing your address, you need to give the other one notice. It might even be 2 days. So whatever you want to put in there. So if you read this section, it'll read like notification of parties' current address. Petitioner and respondent must notify all parties within 2 days, if that's the number you want to put in there, of any change in his or her address for residence. And I would put mailing also, just in case there's a different mailing address to a residence. If you want, you should also notify for a change in the work address. In case somebody changes jobs, or in case they change the location they work, you want to know that if the other parent changes. And you can even mark email address here. So if they change their email address, they need to give you the updated email address right away. B is about telephone numbers or a message phone number. So B says telephone number at home. So if somebody changes their home phone number, you want notice of that right away. Cell phone number, work number, you want to mark that box. And certainly the children's school. So if the phone number of the children's school changes for any reason, you want to give notice of that too, and you want to receive notice of that if it changes. So you want to mark that too. Moving on to number 2. Number 2 is notification of proposed move of the child. This one is hugely important and very important. You want to give at least 45 days notice. You want to write 45 days in that box. And here's why 45 days. You want to have enough or more. You might want to put 60 days in that. 60 is pretty safe. You want to put in that much time because if the other party wants to move with the child, and you want them to give you as much notice as possible so that you can file paperwork, go into court, and make sure you have plenty of time for a hearing to come up so the judge can make orders with regard to a move of the children's address before the move of the children's address. All right, so that's what that is. Number 3, childcare. A says the children must not be left alone without age-appropriate supervision. So if there's a concern in your relationship that the other party is maybe leaving their children unsupervised or without a person of sufficient age to monitor the children, then you're going to want to mark that box. B, the parties must let each other know the name, address, and phone number of the children's regular care providers. You posit whether you mark A or not. That's up to you. But B is really important, so you want to mark B. Okay, so 4 says right of first option of child care. So what this whole paragraph means is if the other party is sometimes unable to care for the children during their visitation time or during their custodial time, and let's say that they're going to be unavailable for, all day, like they're going to work, or if they're unavailable overnight or something to that effect, right of the option, it's basically, we call it a right of first refusal, means that if they're unavailable to care for the children during their time, they have to give you notice so that you can care for the children during their time. So that they're not being, for example, if you're available and you're home, you don't want the children left with a babysitter or somebody else when you're available to take care of the kids, right? So that's what this box is about. On the amount of hours, you need to be careful here. A lot of people are like, well, I'm going to say if he's unavailable for 2 hours, I want the kids. Keep in mind that that's going to be a nightmare to police, and it's going to cause problems. I would suggest that you make it for a considerably larger amount of time, either 6 hours or 8 hours or even overnight. Now keep in mind, if they're going to take off and they're going to go shopping, they could be gone to the grocery store and Home Depot and Sam's Club, something like that, for more than 4 hours. So if you put in there 4 hours, all you're doing is begging for trouble. You're asking for trouble to come down the line when the father or the mother goes to Home Depot, and then they got to go to Sam's Club, and then they got to pick up something specific, milk or something at the grocery store, and they've been gone for 5 hours, and the children have been left with grandma or somebody, or the next door neighbor or whatever, the kid's best friend and his mother down the street. You don't want to say that if they're going to be gone for 4 or 5 hours that you need to have the right to watch those kids. I'm just telling you, you can, but it's going to be trouble. So I would suggest that it be at least 6 hours and maybe 8 hours of length of time that the other parent is not going to be able to care for the children before that they have to tell you that the children can be cared by you. But it's up to you. I typically put like 8 hours there. Okay, number 5 says canceled visitation or parenting time. So this is a paragraph that is about giving notice if you are unable to care for the children. So this may or may not apply to you, so look at this. So A says, if the non-custodial party fails to arrive at the appointed time and fails to notify the other party that he or she is going to be late, then the custodial party need wait only a certain amount of minutes. Okay, so where I'm at, where I practice, there's a lot of traffic. So it's very, very common for the non-custodial party to be coming over to meet or to pick up the children for their visitation. And sometimes, if they're like 10 or 15 minutes late, the party that's got custodial time with the children or the primary custodian might pick up the kids and bolt to a movie or McDonald's and say, hey, sorry, you were late. You missed out on your visitation time. And I have then later represented that party in court and had the judge really come down on that person real hard and say, you left after 10 or 15 minutes. You know, whereas, let's say it's mom, she left after 10 or 15 minutes, and the judge might say, where's dad coming from? Well, dad's coming from, 26 miles away. At what time is dad supposed to arrive? 5 o'clock. So isn't that like the peak of traffic time? Yes. Isn't it likely that there could have been a car accident or something that might have delayed the dad from arriving? Yes. All right, well, from now on, we're going to make it so that you have to wait around a full hour for dad. I mean, the judge might even punish the other parent. So here's what I suggest. I suggest 30 minutes, or at least 20, but I suggest 30. You can put 20 minutes in here. And I would suggest 20 minutes, especially if you have to meet at a central location. So if you have to drive halfway and the other party has to drive halfway, 20 minutes is more than enough time to wait. And if they're late, boom, you're gone. They forfeited their visitation time. That's your argument. Anyway, so unless a judge has ordered some other orders with regard to this, if you're meeting halfway, 20 minutes is probably pretty reasonable. You want to be extra safe, 30 minutes. If the other party is actually coming to your house to pick up the children, and all you got to do is sit there and wait and do, not much, or continue cleaning or cooking for the kids or watching TV or whatever you're doing, I would say a minimum of 30 minutes before they kind of lose their visitation time. So that's my advice on that area. Okay, so B says, if the non-custodial party is unable to exercise visitation time on any given occasion, he or she must notify the custodial party, and there's a box that says at the earliest possible opportunity or other, and you can say within 4 hours. But here's the reality of this. What if they don't know they're going to be late until the very last minute? What if they're on their way, everything's hunky-dory, they're going to get there 5 minutes early, everything's awesome, and then there's a stop-dead traffic accident on the freeway, and there's nobody moving, or there's a pursuit that ended right in front of them, and you're not moving for 2 hours. I mean, at that point, the non-custodial parent should absolutely call the custodial parent and say, hey, look, this is what's going on, I'm going to be late. They should also say, hey, please have the kids available. I don't want to lose all my visitation time if I can get there. So, you know what, I'll give you a break sometime if you'll just hang loose and wait for me to arrive this time. But you may or may not want to put anything. If you're going to mark anything on B, to be reasonable, I would mark B and then at the earliest possible opportunity. C says, if the children are ill and unable to participate in a scheduled visitation time, the custodial party must give notice to the other party, and I would say the same thing, as much notice as possible. You can demand a doctor's excuse should this have happened many times. I mean, if this is an excuse that, say, the custodial parent has used, kid are sick, don't come, don't even show up, I'm not going to send the kid with you. Because, he's sick again or she's sick again or whatever. If this has happened several times, you might want to put in here, or you might want to ask a judge for an order that says, a medical excuse, a doctor's signed written note is required to keep the child from visitations due to illness. All right, moving on to number 6, phone contact between the parents and the children. This is huge. So this basically says that the non-custodial parent should be able to have telephone contact, or even the custodial parent should have phone contact with the kids when they're with the other parent. So let me read them. A says the children may have telephone access to the parties, both parties, and you can mark that box, and the parties may have telephone access to the children at reasonable times for reasonable durations. So this means if the children are with dad for the weekend, mom should be able to call and talk to the kids, and certainly the kids should be able to call mom and say hi during that time when they're with dad. The obverse is true also. So if mom has custody and the kids want to call dad, they should absolutely be able to do that. And if it's mom's weekend and dad wants to call the kidders Saturday evening and say hi to the kidders or say goodnight to them before their bedtime or whatever, that should absolutely be allowed, and parents should absolutely allow that. Now, there's an argument all the time about, well, it's my custodial time and I don't want him bothering me when I've got custodial time, or dad says, my time with the kids is so limited anyway, I don't want her bothering the children or me during my custodial time. Let's not play that game. That's a really, really good way to anger a judge. You need to look at this from the aspect, or from the perspective of the children. The children don't care if it's your time or her time or mom's time or dad's time. If they want to talk to the other parent, if they miss the other parent, they should absolutely be able to have that contact. And frankly, if you want contact with the kids during mom's time or dad's time, then you should absolutely be willing to have them have phone contact with the kids during your time. So keep that in mind. B says the custodial parent must make the children available for the following scheduled telephone contact. So this is if you want to make very specific orders. For example, let's say one parent has custodial time all during the week. So Monday through Friday they're with one parent. And the other parent wants to have a fixed schedule. So they want to say on Mondays, Wednesdays, or Tuesdays and Thursdays from 7 o'clock to 8 o'clock at night, they should be able to call for a reasonable duration, say 15 or 20 minutes. So anytime during that hour of 7 to 8 o'clock, dad can call mom's house to talk to the kids for 20 minutes. That kind of thing, that can be written in here. C says no party or any other third party may listen to, monitor, or interfere with the calls. You absolutely want to mark that if you're setting up telephone conversations, because you don't want the other parent interfering or monitoring those phone calls. Because who does that harm? That harms the kids. The kids don't want, mom spying on dad and dad spying on mom. And frankly, they might want to say something to dad that they don't want mom to hear. And kids should be able to do that. I mean, if they're hiding things and they're lying, that's obviously not good. But if they have this thing, a private joke with dad or whatever, they should be able to do that even during healthy, familial relationships, marriages, happy marriages. Kids have a different relationship with dad or a different relationship with mom that they don't actually share with dad. Look, just, understand that kind of thing. And be receptive to that. All right, page 2. Top of the page, make sure you list the petitioner and the respondent as required. The case number off to the right. Number 7 says no negative comments. This is the old no disparaging comments about the other party to the kids. It's very common to mark this box. It basically just says, do not say anything crummy about me to the kids when they're in your care. And it also usually says third party. So let me read it to you. The parties will not make or allow others to make negative comments about each other or about their past or present relationships, family or friends within the hearing distance of the children. This is a really simple one to mark. Now, policing it and making sure it doesn't happen is a whole different difficult problem. But it doesn't hurt to mark it and just hope that the other parent's going to, play by the rules. Number 8, Discussions of court proceedings with the children. This is huge. Judges hate it when you are talking to the kids about the court case or about the details of your case. Just mark this box and don't ever do it. Again, you'll never understand how much harm this brings to the kids if you do this. So just don't do it. It's truly harmful to the kids if you put them in between you. Okay, moving on. Number 9, no use of children as messengers. This is a good one. It just says don't carry messages to the other parent. Don't deliver messages to the other parent through the kids. Don't say, hey, give your mom the child support check. Don't do that. Mail it. Wire it. Electronic transfer it. Venmo it. I don't care how you do it. Don't send a check with the kids. It's just not good. You don't ever want them to even be in the middle, even for something little like that. Even if you think it's positive, hey, I'm giving mom money. No, it's child support. It's a divorce thing. It's a child custody visitation. Don't do it. All right. Alcohol or substance abuse, and certainly don't send a message to them that says, hey, tell her not to show up at the graduation. This is my custodial time. Definitely none of those kind of messages. All right, 10, alcohol or substance abuse. So if alcohol or substance abuse issues are a factor in your case, look through this one, and you may not mark it down. One of the things in here says, one of the orders you can put is that the petitioner, the respondent, or whoever may not use alcohol a blank amount of hours before the visitation schedule. It's very common to say you cannot, if there's alcohol is a problem, if alcohol abuse is potentially a problem, you might want to have an order that says you cannot use alcohol for 8 hours or 10 hours prior to or during any visitation schedule with the children, or any custodial time with the children. Because, if you say just during the custodial time, mom or dad, the other parent, could get completely hammered an hour before the children show up and still be drunk, all through the visitation. Something to be aware of, and that's on there. 11, no exposure to cigarette or medical marijuana smoke. So you may want to just put this in there anyway, but it's super common to have this kind of order when a child has asthma or some other kind of breathing difficulties or issues or health concerns that would be affected by smoke. 12, no interference with the schedule or any party without the party's prior consent. This should go without saying. It's just, the parties will not schedule activities for the children during the other party's scheduled visitation parenting time without the other party's prior agreement. It should be common sense, but it's not uncommon for one party to sign a kid up for dance that also takes place on, or baseball or whatever it might be, swimming lessons, during the other parent's weekend visitation time. Be very careful there. A judge could say, sorry, I know you paid for it. I know the kid's been going. The child's excited about going to his swim classes, but I'm going to cancel it because you did it on your own and you did it during dad's time, or something to that effect. Be careful. 13, third-party contact. This is if there's a concern that there's some third party, a family member, brother, cousin, neighbor, roommate, somebody that could be a danger to the children. So A says the children will not have contact, and then you could put a specific name in there. B says the children must not be left alone or in the presence of, and the specific name. So one says no contact, even if they're in the presence of a parent. The other one says you can't be left alone with them. So keep that in mind, and if it's helpful or needed, complete number 13. 14 says children's clothing and belongings. This is starting to get really petty, but it says that A, each party will maintain clothing for the children so that the children do not have to make the exchanges with additional clothing. So it should seem pretty obvious. If you've got regular visitation with your child, they should have toys and clothes and a bed and all the things you need to raise your child and keep your child at that home. You shouldn't have to carry a bag back and forth from mom or dad's house every time they travel. That is not good. You shouldn't even have to transfer the car seat from one car, from mom's car to dad's car, from dad's car to mom's car. Get your own car seat. You need to do it. Your child is worth it. I know they're expensive. Figure out a way to get an approved, proper child seat one way or another so that you don't have to trade them or, you know, whatever. Okay, so B under 14 is the children will be returned to the other party with the clothing and other belongings they had when they arrived. I hate this order. Judges hate this order. But if you and the other parent cannot get along, and the discourse between you is so pervasive that you can't even trust the other parent to send the child over in clothing from your house because it's going to get scooped up and kept at the other house, then just send the child back in the clothing that they came in, and you can mark this box so that that's expected every time. The problem with that is if the visitation's only 2 days long, then literally a child could end up staying in the exact same clothing for the entire 48-hour visit or whatever. Or you have to clean the clothes, you know, in a short time every time they... Look, try to get along with each other, folks. That's what I have to say on that one. 15, logbook. Very rare, but if it's really, really bad, you can mark this one. The parties will maintain a logbook and make sure that the book is sent with the children between their homes using business-like notes, no personal comments. Parties will record information related to health, education, and the welfare issues that arise during the children's custodial time with you. All right. Very rare, and, you know, goodness knows. We really don't have to do that one very much. But if you have to, you know, that's an option. All right. Terms and conditions of order may be changed. So this is a good one. 16 says the terms and conditions of this order may be added or changed as the needs of the children or parties change. Such changes will be in writing, dated and signed by the parties. Each party will retain a copy. If the parties want to change to be a court order, it must be filed with the court in the form of a court document. I'll tell you what judges prefer other than marking that. Judges prefer that you work together and co-parent caringly. I don't even know if that's a word. You know what I'm getting at. They want you to be able to work together and co-parent your children properly. So try to do that. If you can't, then you could mark 16. If there's any other provisions or anything else you agreed to or anything else the judge ordered, like the judge could order that, you know, mother must take the children to a prescribed therapist or something on, you know, Wednesday evenings once a week, then that could be in the other, or whatever the judge might have ordered, or whatever you guys agree should be in the order can be on the other section. That's it for this form. That's the additional provisions physical custody attachment FL 341D. Again, this is a form that will be attached to some other form like a judgment, an order, a petition, a request for order, or a responsive declaration to an order. It's going to be used along with other forms. Thank you. I hope this video was very helpful.